Good morning, ladies and gentlemen. My name is Judge Lal, and we are going to commence with our state all-purpose calendar. This is the Fulton State Court, and today is April 28th, 2022. This is a calendar in which we address, it's basically a plea and arraignment calendar for individuals who may still be who are still detained at different facilities. And we are going to see if they would like to have a plea hearing or whether their cases will be arraigned and scheduled for a trial in the future, or perhaps address other matters such as bond reconsideration. If you are a defendant with an open, active misdemeanor case against you, please remember that you have a right to remain silent about the facts of the case. Anything you say during the course of this proceeding, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, or if you've not retained your own counsel, one of our attorneys from the Public Defender's Office or the Conflict Defense List will be representing you. All right, let me see. I have both South Annex and Courtroom 2 and 3 South. So, excuse me, 5 South. Am I addressing 5 South first?
Yes, ma'am. Number 14, Mr. Nora.
Repeat that case number again, please.
Number 14.
Thank you. I have Antonio Nora, case number 22 CR 002237A, accused of criminal trespass from April 13, 2022. Mr. Nora, you've been advised of your right to remain silent, and your attorney is Mr. Zach Findling. Mr. Findling, this will be a negotiated plea.
Good morning, Judge Law. And yes, this will be negotiated plea.
All right. Mr. Nora, for purposes of this plea, may I place you under oath?
Yeah.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
All right, please put your hand down. Mr. Walker, good morning, sir. What is
Good morning,
the
Judge.
recommendation?
Yes, Your Honor. The state's recommendation is a time served offer. The defendant has been in custody for 5 days. That will be a suspended balance with the condition of a stay away with the address of 469 Marietta Street, located here in Atlanta, Georgia.
Thank you. Mr. Findling, anything else?
Nothing further, Judge. That is our understanding of the recommendation, of which we do agree, and additionally stipulate the factual basis, venue, and ID.
Thank you, sir. Mr. Nora, have you consumed any kind of medication, alcoholic beverages recently?
No.
And have you understood the proceedings so far, as well as the explanation of your attorney?
Yeah.
And are you satisfied with this representation?
Yeah.
If you decide to take this plea today and plead guilty to criminal trespass, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to be able to confront your accuser, challenge the state's evidence, present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Repeat?
Yes.
How do you plead to one count of criminal trespass?
You.
Your sentence is time served. If you have no other holds at the Fulton County Jail, you'll be released within 24 hours. And please do not return to 469 Marietta Street in Atlanta, Georgia. Otherwise, you'll be arrested again.
Yes, ma'am.
Thank you. That concludes this case.
Okay.
All right, we have position number 2, Mr. Brad Davis.
All right, thank you. On Mr. Brad E. Davis is case 21 CR 005478F. Mr. Davis, you've been advised of your right to remain silent, and your attorney is Mr. Zach Findling. Are you aware of the charge brought against you, sir?
Yes, Your Honor.
All right. This is going to be a negotiated plea. So, Mr. Davis, may I please place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Walker, without referencing the specific charge, what is the recommendation?
Your Honor, I'm sorry, can I have the position number?
Position 2, Brad E. Davis.
Okay. And you asked for the plea recommendation. That is
Yes.
12 months is served, 18 days, credit for time served, 9 days, balance probated with the conditions of no further contact with MARTA employee Melvin Amy. And there's also a stay away condition. Give me 1 second. I will give you that location. That is the North Springs MARTA station.
All right. Mr. Finley?
Yes, Judge. That is our understanding of the recommendation, of which we do agree. We would just ask that probation fees would be waived for Mr. Davis, as finances are an issue in his life.
And he's got a specific address, right, while he completes his evaluation and treatment?
So he was unable to give me an address, but he gave me his dad's phone number, and he will be staying with his dad. So I'm going to reach out to his dad and get his address from him.
All right, and he'll have to report to probation by, today's Thursday, by next Tuesday, which is May 3rd, I believe. Yeah. And that would be at 132 Mitchell Street in Atlanta, Georgia. Oh, did I just lose the Zoom? No, I didn't. Okay, sorry about that. And do you stipulate to the factual basis, venue, and ID for this charge?
I do, Judge.
All right, thank you. Mr. Davis, first of all, have you consumed any kind of medication or alcoholic beverages recently?
I've been taking Rimra.
Okay, and even with this medication, have you been able to understand the proceedings so far?
Yes, ma'am. Yes, Your Honor.
If you understood your conversations with your attorney,
Yes, Your Honor.
and are you satisfied with his representation?
Yes, Your Honor.
Has anyone forced you or induced you to take a plea today?
No, Your Honor.
All right, and you do understand that if you decide to enter a guilty plea to this charge, you would have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel so that you could confront your accuser, examine witnesses, argue your case to the trier of fact, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to the one misdemeanor charge brought against you?
Guilty.
All right. Your sentence is 12 months to serve 18 days, credit for time served 9 days. If you have no other holds in Fulton County Jail, you should be released within 24 hours. Once you are released, you must report to the Fulton County Probation Office located at 132 Mitchell Street in Atlanta, Georgia, no later than next Tuesday, May 3rd, 2022. Do you understand?
Yes, Your Honor.
You must report to that office and be placed on probation so that you could complete your evaluation as well as submit yourself to any treatment that's required. Your probation office will inform you as to who the providers that you could go to. Do you understand?
Yes, Your Honor.
That's very, very important. Also, you need to update your probation with your mailing address and all your other contact information. Do you understand?
Yes, Your Honor.
You are also to stay away from the North Springs MARTA station. So I guess you can use MARTA to some degree as long as you don't stop at the North Springs MARTA station, and you're to have no further contact with the MARTA employee named Melvin Ames. Do you understand?
Yes, Your Honor.
All right. Anything else, Mr. Finley?
Nothing further. Thank you.
All right,
Judge.
thank you.
Next, we got position number 6. Position number 6. Mr.
I sent a
Brown.
message to South Annex. If they could check their message, please. Thank you.
Oh, yes, sorry. For Mr. Davis, his fees will be waived for the first 6 months. Yeah. All right. All right, Mr. Finley, you still need to speak to position 10 and position 7?
Yes, Your Honor. South Annex just called me. I'll go ahead and do position 6. And then after that, if we can do one of PD Helen's And I'll give South Annex a quick call. They're both 10 and 7 are both South Annex, so I'll talk to both of them.
All right, and all right, Ms. Webb, I got your note as well. Okay, I'm sorry, this was position 7. I'm sorry, did you say position 6 or 7?
Position 6, Your Honor.
6, okay,
Farrell.
thank you. Justin Kirby Farrell, case number 20 COB 000366, accused of simple battery and misdemeanor possession of marijuana from July 31st, 2020. And with regards to this case, Mr. Farrell, you've been advised of your right to remain silent, and your attorney is Zach Finling. May I place you under oath for your plea hearing?
Yes, ma'am.
Do you solemnly, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Walker, what's the recommendation for Mr. Justin Farrell?
Yes, Sean, to the 1 count of simple battery, the state's recommendation is time served. The defendant has been in custody for 193 days, balance suspended with no further contact with the victim, whose name is Kareem Kaba, last name is spelled Kaba, with a stay away from the address of 1980 DeLoe Drive Southwest. In exchange for that plea, we will be not processing count 2.
All right. Mr. Finling, anything else to add?
Nothing further, Judge. I would do agree to the state's recommendation and additionally stipulate to the ID and venue.
On factual basis, correct? And factual basis.
That's correct, Judge.
All right, thank you. Mr. Farrell, have you recently consumed any kind of medication or alcoholic beverages?
No, ma'am.
Repeat?
No, ma'am.
Okay, and you've been represented by Mr. Finling. Are you satisfied with this representation?
Yes, ma'am.
And you have understood the proceedings so far?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
And if you decide to take this plea, you would have to give up your constitutional rights to go back to court, to have a trial in front of a judge or a jury, to be able to have the assistance of counsel to challenge the state's case, present your own defenses, examine witnesses, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the 1 count of simple battery?
Yes.
Okay, I accept your plea. Your sentence is time served. You'll be released within 24 hours if you have no other holds at the Fulton County Jail. After you're released, you are to have no contact with Kareem Kaba, and you are to stay away from 1980 DeLoe Drive in Atlanta, Georgia. If you return to that location, you could be arrested again for trespass. That's it. Thank you.
Excuse me. May I ask for Mr. Finley phone number?
I'm sorry, repeat your question.
Good morning, Mr. Finley.
Hey, Sir, I would recommend if it's regarding the facts of your case,
Yes, sir.
I would not ask right now. We're on the record. If you need to, we can talk a little bit later. That works.
Yes, sir.
All right. That concludes this case. Thank you.
So we're going to Ms. Helen's cases now?
If we
Yes.
could, I'm just going to call the South Annex.
Okay, we got position number 24, Mr. Ricky Sanders.
Thank you.
Thank you. This is Ricky Sanders, case number 22 CR 002266C. Mr. Sanders has been accused with battery, domestic violence, hindering a person from making an emergency phone call, and criminal trespass, domestic violence from April 14th, 2022. Mr. Sanders, you've been advised of your right to remain silent. Your attorney is Ms. Catrice Helen. And Ms. Helen, we are doing a negotiated plea, correct?
That is correct, Judge.
Thank you. Mr. Sanders, if you please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. You may lower your hand. Ms. Webb, good morning.
Good morning, Judge Law. How are you?
Fine, thank you. What is the state's recommendation?
Yes, Your Honor. The state is recommending 12 months to serve, 30 days, credit for time served, 15 days, Family Violence Intervention Program. No further contact with Miss Ashley White. That's Ashley common spelling, White common spelling. A stay away from 375 Berkshire Lane. That's BARKSHIRE Lane, Roswell, Georgia, N10775 House Road, which is the SMZ Auto Imports, and no alcohol, drugs, or weapons.
Yes, Your Honor, that is our understanding of the recommendation. We agree to it. We stipulate to the factual basis, venue, and ID. Judge, we would just ask you that once his conditions are completed, if it could be non-reporting, we ask for the first 6 months to be waived because he's not working, and I'd like for him to be successful reporting to probation, Your Honor.
Does he have a specific mailing address?
Yes, Your Honor, I have.
Oh, no, you don't have to announce it. I
Okay.
just want to be sure that we have an address for probation.
Yes, Your Honor, I have a phone number as well as an address.
Okay, so, and it's current, right?
Yes, Your Honor.
Okay, so probation will send him a notice of when to show up and report to probation.
I just want to clarify, they won't be given that court date or the report date today. They're gonna.
I do believe, and JCS is on the Zoom. I'm always clarifying.
Ma'am, I'm here.
Yes. With regards to probation, if you have a specific address, you send them a notice to appear.
We'll call him
Call
to
me.
let him know. Yes, ma'am, we'll call him and let him know department time and date.
All right. So-
Understood.
And we also send, excuse me, we also send text messages.
Repeat that?
We also send text messages. So once I give him a verbal, once I talk to him, I also send him a text message so that he'll have it in his phone too.
All right. Thank you.
You're
So Ms. Helen, he has a valid phone number which can receive both voice and text messages, yes?
Yes, Your Honor.
Okay, thank you. All right, and I'm sorry, we stipulate to the factual basis, venue, and ID for all charges?
Yes, Your Honor.
Okay. Mr. Sanders, we can unmute courtroom 2, please. All right, Mr. Sanders, we are going to address your plea of guilty to these charges in exchange for a recommended sentence. First of all, have you consumed any kind of medication, drugs, or alcoholic beverages recently?
No, ma'am.
Repeat, please.
No, ma'am.
Okay, and have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with the representation you've received from Ms. Helen?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
And do you understand that once you take this plea, you'll be placed on probation until all the conditions have been satisfied?
Yes, ma'am.
Furthermore, Mr. Sanders, if you decide to take this plea, you will have to waive your constitutional rights to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel so that you may be able to confront your accuser, challenge the state's evidence, present your own defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, domestic violence, hindering a person from making an emergency phone call, and criminal trespass causing domestic violence?
Guilty, Your Honor.
Your sentence is 12 months to serve 30 days. You'll be given credit for 15 days. So technically, you will be released within 24 hours, unless you have any other cases holding you at the jail. Once you are released, probation will contact you via phone as to when and where to report to probation. Do you understand, sir?
Yes, ma'am.
All right, if you don't hear from them within the next 2 weeks, I highly recommend that you go and report to 132 Mitchell Street. Do you understand?
Yes, ma'am.
Once you're reporting to probation, you will then have to complete a 6-month family violence intervention program. And you need to stay away from 2 locations specifically, 375 Berkshire Lane in Roswell, Georgia, and the business known as MSZ Auto Import at 10775 House Road in Roswell, Georgia. While you're on probation, you're not to consume any alcoholic beverages, no illegal drugs, and you're not allowed to possess any weapons or firearms. You're also to stay 200 yards away from Ashley White, and you're not to contact her in any way, form, or manner. Do you have, and I will waive your probation fees for the next 6 months, including the month of May. Do you have any questions about your sentence?
No, ma'am.
All right. Thank you. That concludes this plea.
Thank you, Judge.
Okay,
Yes.
next we have position number 25, Mr. Simpson.
Thank you. Raphael Mcgee Simpson, please.
Yes.
Oh, there he is, at 4 South. So let me place you at the right spot. All right. You are Mr. Simpson, is that correct, sir?
Yes, ma'am.
All right, Mr. Simpson, my name is Judge Lal, and we're going to address a possible plea hearing with regards to your case. This is Raphael Mcgee Simpson, case number 22 CR 002-281B. Mr. Simpson has been accused of criminal trespass, giving false information to a law enforcement officer from an incident date of April 15, 2022. Mr. Simpson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you today is Ms. Catrice Helen. For purposes of this plea, may I place you under oath? Mr. Simpson, may I place you under oath?
Yes.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Webb, what is the recommendation for this case?
Yes, Your Honor, the state is recommending 12 months to serve, 28 days, credit for time served, 14 days, with the balance suspended, a stay away from 1011 Northside Drive, Northwest, which is the Catalyst Midtown Apartments, and no alcohol, drugs, or weapons.
Yes, Your Honor, that is our understanding of that plea. We do accept it. We do stipulate to the factual basis, venue, and ID.
All right. Since it's balance suspended, there's no monitoring after that, it would be difficult to enforce the no drugs, alcohol, and weapons. So I'm going to dispense with that requirement. Mr. Simpson already knows he can't be consuming illegal drugs, and unless he's properly licensed, he's not allowed to own a firearm, at least outdoors. Okay. All right. So, Mr. Simpson, first of all, have you consumed any kind of medication, drugs, or alcoholic beverages recently?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with the representation you've received?
Yes.
And is anyone forcing you to take a plea today?
No, Your Honor.
Repeat?
No.
Okay. Mr. Simpson, if you decide to take this plea today, you would have to give up your constitutional right to be able to challenge this case in a court of law. You would have to give up your right to a trial by judge or jury, to be able to have the assistance of counsel, to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of criminal trespass and 1 count of giving false information to a law enforcement officer?
Yes, I plead guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. Your time at the jail is concluded and you'll be released within 24 hours unless you have any other cases holding you. Your balance of your sentence is suspended, but you cannot return to the location known as Catalyst Midtown at 1011 Northside Drive in Northwest Atlanta. If you return to that location, you'll be arrested again. Do you understand?
Yes, ma'am.
Do you have any questions about your sentence?
No.
That concludes this case. Thank you.
Thank you.
Position 7 South Annex, ma'am.
All right. Is Mr. Finling ready now?
Yes, Judge, I'm ready.
All right. We have Equisha Foot, case number 17 CR 027695Y. Ms. Foot has been accused of 2 counts of reckless conduct. And Ms. Foot, you have been advised of your right to remain silent, and your attorney is Zach Finling. What's the announcement, Mr. Finling?
Sorry, I was on mute. Yes, Judge, this will be a negotiated plea.
All right. And she's completed the documents and they have been sent to Ms. Katrina Lewis.
I just asked her the questions. I will fill out the paperwork and be sent to you after court, Judge.
All right. All right. Ms. Foote, I understand that you've decided to accept the recommendation from the state in exchange for a guilty plea to these charges or charge. So the prosecutor is going to let me know what the recommendation is. And then after that, I'll hear from your attorney. For purposes of this plea, may I place you under oath? Ms. Foote, may I place you under oath?
Yes.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Walker, what's the recommendation, please?
Yes, Sharon, the state's recommendation to the 2 counts of reckless conduct to run concurrently is 12 months to serve, 48 days, credit for time served of 24 days, balance probated with a $300 fine on each count for a total fine amount of $600 and no contact with the 2 juvenile victims. If it's okay, I can place their names in the chat.
I can just take the initials for now.
Okay, give me 1 second. Let me pull it up, Your Honor. It's on a different screen. So one of their initials is BC, and the other initial is KF.
E as in England, C.
Is B as in boy, C
Okay.
as in Carter, and then the second victim's name is K as in kite, F as in Frank.
Okay. And this was no further contact or no further violent contact, or is there a defects protocol as well?
So there isn't a current defects protocol, but it was a no further contact.
Okay. Thank you. Mr. Finling, are these the terms to which your client has agreed, and in addition to the no further contact?
Yes, Judge. These are the conditions of which my client has agreed. We were just asked, she did agree to the fine, the $600 fine. We just asked that once she does that, if her probation could either be non-reporting.
All right.
There's no objection, Your Honor.
Okay. It's $300 in each count, so it's a total of $600. Okay.
That's correct.
All right. And Mr. Finling, do we stipulate to the factual basis, venue, and ID for these 2 counts?
We do, Judge.
Ms. Foote, you've been represented by Mr. Finling. First of all, have you consumed any kind of medication or alcoholic beverages recently?
Ma'am.
Repeat?
No, ma'am.
Okay, I'm sorry, the audio is not very clear.
No, ma'am.
You may have to put your mask on, just speak a little louder, that's all.
Okay, no, ma'am.
Appreciate that, thank you. Ms. Foote, also, have you understood the proceedings so far, including the explanations given to you by your attorney?
Yes, can I address something?
I would strongly, yeah.
Oh,
With regards to what?
but those are my kids y'all talking about. They grown now.
How old?
Ariel is 21, should be 22 in July, and my son is 17, which he's in mental health. He's like in a mental health.
So let me ask
We
you,
would,
first of all.
yeah, we would oppose, the no contact.
So
B-
I have 2
Yeah.
different victims listed, so I'm not sure.
Yeah,
I had that she was babysitting someone else's children.
yeah, I'm a little
No.
confused as to,
Yeah, I didn't know. I thought this was something else. I'm really confused, but I still go with my plea. But I just want to address
No.
those are my kids.
Miss Foote, then I'll have to call you. I can call you back and we can go over this if you're confused. I don't need to be
Okay.
confused.
No. Go ahead. We good. Go ahead.
No, we're not.
No,
No,
Okay.
we're not.
yeah,
Finley, I could put the children's name in the chat directly to you so she can know
Okay.
exactly who we're referring to.
yeah,
I
if you
know it's
could.
an older case, so that might help.
Yeah, I know exactly who you're talking about now. Now that I know, it's Ariel Watkins and Dayon Foote.
That's not the names of the victims now.
Oh,
Yeah,
okay.
yeah, I'm gonna have to call you. Yeah.
Okay.
I'll be right back.
Okay.
Thank you. South Annex, we will address Ms. Foote after Mr. Pending has had a chance to speak to her again.
Yes,
We're
ma'am.
going to move on to courtroom 2. Who do we have, please?
Your Honor, we have position number 27, Mr.
Okay.
Thomas.
Thank you. I have Almatres Javon Thomas, position 27. This is case number 22 CR 002117B. Mr. Thomas was accused of criminal trespass from April 7th, 2022. Mr. Thomas, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. This is going to be a negotiated plea according to the announcement, so may I place you under oath? The other right hand.
And the other hand.
Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. Ms. Webb, what's the recommendation for Mr. Thomas?
Yes, Your Honor, it's 12 months to serve 21 days, credit for time served 21 days with the balance probated, 20 hours of community service and a stay away from 200 Edgewood, Atlanta. Your Honor, albeit this is a criminal trespass, he is a repeat offender at this particular location. And that's the reasons for the.
Is that the student housing?
It's not officially student housing, but it is a student housing complex that's on that's near the Georgia State campus, but it's not a Georgia State owned housing facility.
All right. Fancy location though. All right. Miss Helen?
Yes, Your Honor, that is our understanding of the plea. We do accept it. We do stipulate to the factual basis, venue, and ID. I just ask that once Mr. Almatres completes all of the conditions, can it be non-reporting as well as a waiver of the first 6 months of the probation fees?
First 6 months? He only has 20 hours to complete.
Or first
Okay.
3, Your
I'll
Honor.
waive probation fees for the month of May. Got a whole month. Is he employed? Is he busy?
No, Your Honor, he's not.
All right. And any objection to non-reporting, Ms. Webb?
In this particular case, Your Honor, since this is a repeat offender case, we are opposed to it being non-reporting.
All right. Let me think. So I'm familiar with this location. It's predominantly student housing as part of the GSU complex. And you're absolutely right, Ms. Webb, it's more of a private student housing rather than a part of the university system. And from what I understand, beginning at least May, June, we're getting into the summer term. I don't know whether it's that occupied. So I'm trying to understand why I should not put him on non-reporting basis. I mean, if he shows up, not only will he be arrested again, his probation could be revoked.
Correct, Your Honor. In this particular case, so again, there's just been like repeat cases with this. He was already administered another stay away notice, which he violated, Your Honor. It appears that he does have an ongoing conflict with a resident at that particular that resides at 200 Edgewood. So not understanding what that underlying conflict is, we just want to, of course, protect the residents' interests and the other residents, Your Honor, just to ensure that nothing does arise. But if Your Honor is inclined to give that non-reporting condition, that's fine. I just wanted to put on the record that we're opposed to it, considering the facts of the case.
All right, Ms. Helen, is your client a student at GSU?
No, Your Honor, he's not. And so we understand if there is he understands to stay away from that location, but as far as the probation not going to non-reporting when the condition is completed, we understand.
Okay, thank you. All right, Mr. Thomas, first of all, have you consumed any kind of alcoholic beverages or medication or drugs recently? And we need to unmute courtroom 2. Hang on, let's unmute it first.
No, ma'am, I haven't.
All right. And have you understood the proceeding so far, especially the discussion about staying away?
Yes, ma'am, I have.
And are you satisfied with the representation of your attorney?
Yes, ma'am.
If you decide to take this plea today, You would have to give up your right to go back to court and have a trial before a judge or a jury. You would also have to give up your right to have the assistance of counsel to be able to confront your accuser, challenge the state's evidence, present your own defenses, examine witnesses, and have the state, the prosecution, try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I am.
Is anyone forcing you to take a plea today?
No, ma'am.
How do you plead to the one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 21 days, credit for time served 21 days. That's a long time to be in jail for a trespass issue, especially when it's so easily fixed by simply staying away. You are to be placed on probation. I'm going to waive your probation fees for the month of May. There are 31 days in the month of May, and you will have to complete 20 hours of voluntary community service. Do you understand?
Yes, ma'am. May I ask for the length of the probation?
Well, your probation is going to be for 11 months and 1 week. Do you understand?
Yes, ma'am.
11 months and 1 week. If you violate the terms of your probation, we can revoke it and have you spend the rest of the time in jail. Simple as that. I think 21 days is a long time, but you decide if you want to spend more time in jail. And the way that would happen is if you go back to 200 Edgewood. Okay?
Yes, ma'am.
You cannot be on the sidewalk next to that building. You can be on the sidewalk across the street, but you cannot be anywhere in that building or on the same side of the building, not in the parking lot. And that would be for the rest of the 11 months and 1 week. Like I said, in the month of May, you will complete 20 hours of community service. If you take longer to complete 20 hours of community service, you will continue to report to probation and pay probation fees every month beginning June 1st, 2022. If you complete your 20 hours in the month of May, your probation will be non-reporting, which means you don't have to report and you don't have to pay. Are you following me?
Yes, ma'am.
But while you are on non-reporting probation, you are still required to stay away from 200 Edgewood, Atlanta. If you are anywhere near that location, you will be arrested and your probation may be revoked and you spend the rest of the time of the 11 months remaining in jail.
Yes, ma'am.
Do you have any questions about your sentence?
No, ma'am.
That concludes this case.
Thank you, Judge.
South Annex Position 7, Ms. Foote.
Thank you. Going back to Ms. Foote. All right. Mr. Walker, is no further contact with BC and KF? Oh, Mr. Finley?
Yes, Judge. Yes, Judge. Yes, I did speak with Ms. Foote. So she is okay with the no contact from initials BC, Ms. Carter, but she does want contact with KF, who is her daughter.
Mr. Walker?
You know, that's according to the report, the mother's name is Noisha Carter. I mean, I'm not sure how many mothers you can have. I'm just going based off the information that's provided in the report.
I believe Noisha Carter, that's the mother's name, correct? And then Briasha Carter is the daughter?
Correct.
Right. So
we'll go with no further violent contact. There was just a concern because she was arrested in 2019 for battery, family violence, and cruelty to children, and she pled out to simple battery, family violence. So this isn't the first incident where children have been involved. But Kamari Foote is her daughter. We'll go with no further violent contact.
Has the state conferred with both these individuals?
There are juvenile individuals, so.
I mean, whoever's looking after them, has there been any
No,
contact?
there was a DDS investigation. However, they weren't able to complete it because they were unable to locate the mothers.
So, and the state is satisfied that the defendant is the biological parent of the minor KF?
Yes, Your Honor.
All right. With regards to this particular plea, Ms. Foote, I understand that you've already spoken to your attorney, Mr. Findling. And do you understand what no further contact and no further violent contact mean?
Yes.
All right. So with regards to these 2 counts of reckless conduct, again, I'm going to ask you, have you understood the proceedings right up to this point?
Yes.
And have you understood the terms of the recommendation offered by the prosecutor?
Yes.
And do you understand that you'll be placed on probation to pay a fine? And then after that, your probation will be non-reporting, which means that although you're not reporting in person to probation, you'll still be considered on probation.
Yes.
All right. And is anyone forcing you to take a plea today?
No.
And are you satisfied with the representation you received?
Yes.
If you decide to plead guilty to these 2 counts of reckless conduct, you would have to give up your constitutional rights to go back to court, to have the assistance of counsel, to have a trial in a court of law. You would have to give up your right to confront your accuser, examine witnesses, challenge the state's evidence, present your own defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to the 2 counts of reckless conduct?
Guilty.
Your sentence is 12 months to serve 48 days, credit for time served 24 days. If you have no other holds at the Fulton County Jail, you should be released within 24 hours.
Okay.
While you're on probation, you will pay a $300 fine for each count. There's a total of $600. And you will report to probation every month. You will report to probation every month.
Okay.
I'm going to waive your probation fees, all of them, but you will report to probation every month.
Okay. So that means I don't have to pay anything, just report for 11 months. I mean 12
Well,
months.
it's not just report. You'll be reporting, you'll be paying your fine,
Okay.
you'll be making sure that you don't get arrested again for anything else.
Okay.
And you're going to make sure that you have no further contact
Okay.
with the individual named BC.
Okay.
Stay 200 yards away from BC. Do not address this person directly or through any kind of computer device, phone device, through a third party or any kind of social media.
Okay.
You can have no further violent contact with KF, which means there cannot be any physical and verbal altercations with KF. If there are any future altercations and the police get involved, your probation will be revoked. You'll spend the rest of the time in jail or in prison, and most likely will have no further contact with KF.
Okay.
Do you have any questions about your plea or your sentence?
No, ma'am. Thank you.
All right, this concludes this case. Thank you.
Position 10.
Thank you,
One
Judge.
second, Your Honor. Mr. Finley, can
Yes,
you please call 22392, 22392? And can we go back to Ms. Helen's cases here, Your Honor? I have a couple of people here that I really need to bring back to the floors.
All right, Courtroom Two. Who's
Thank
first? Who's next?
Position number 28, Mr. Tompkins.
Ms. Helen, ready to proceed? Ms. Helen?
Yes, Your Honor.
Okay. We have Solomon Alexander Tompkins, position 28, and his case number is 22 CR 002267Y. Mr. Tompkins, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. For purposes of this plea hearing, may I place you under oath?
Yes.
Raise your right hand. Do you solemnly swear and affirm the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Webb, what is the recommendation for Mr. Tompkins?
Yes, Your Honor. The state is recommending 12 months to serve 30 days, credit for time served 15 days, balance probated, a family violence intervention program, no further contact with Miss or Mr. Gentineel Tompkins, that's JANTINEAL Tompkins, TOMPKINS. Stay away from 2093 Lennox Road Northeast, and no alcohol, drugs, or weapons. Nothing further, Your Honor.
Yes, Your Honor, that is our understanding of the plea. We accept that plea. We stipulate to the factual basis, venue, and ID. We would ask, since it is 6 classes for the first 6 months, fees be waived for Mr. Tompkins, as well as if he does complete those conditions, that it be non-reporting.
Ms. Webb, non-reporting after November?
Your Honor, give me 1 second just to verify one quick fact. Yes, Your Honor, state's not opposed to non-reporting for Mr. Tompkins.
It'll be non-reporting. If he completes all classes, fees will be waived up to and including November 2022. All right.
Thank you, Judge.
All right.
No, Your Honor.
Mr. Tompkins, have you consumed any kind of medication or alcoholic beverages recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to plead guilty to the charge today of simple battery, domestic violence, you would have to give up your rights to go back to court to have a trial before a judge or a jury. You would also have to waive your rights to have the assistance of counsel, to challenge the state's evidence, confront your accuser, have the ability to examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of simple battery, domestic violence?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other holds, you'll be released within 24 hours and be placed on probation. Do we have a good address on Mr. Tompkins?
Yes, Your Honor, I do, as well as a good phone number.
Okay. The probation services will contact you via phone and text messages. So please be on the lookout for them. You will have to report to probation, and while on probation, you need to complete your family violence intervention program. That's a 6-month-long program, and that would be at your expense. While you are on probation, active or non-reporting, you are to have no contact with Gentineel Tompkins and stay away from 2093 Lennox Road in Northeast Atlanta. While you're on probation, you're also not to consume any alcoholic beverages, no illegal drugs, and you're not to possess any weapons and firearms. Your probation fees are waived up to and including November 2022. You will start paying probation fees from December 1st, 2022 onwards, and you will report to probation as long as your conditions are still incomplete. Do you understand, sir?
Yes, ma'am.
Any questions about your sentence?
No, ma'am.
That concludes this case. Thank you.
Thank you, Judge.
Next, we have position number 11 and 12, Mr. Johnson.
And Judge, on these, position 12 will be a negotiated plea, and then position 11 will just be an arraignment.
Do you waive for reading of the accusation?
I do, Judge.
All right. Is Mr. Johnson at 4 now?
Yes, ma'am.
Okay, thank you. We have Samuel Lewis Johnson, who has 2 cases before the court. Mr. Johnson, do I have your attention, sir?
Yes, ma'am.
My name is Judge Lal, and I want to remind you of your rights. You have a right to remain silent about the facts of both the cases in front of us. Anything you say about those facts, your statements can and will be used against you. You have a right to an attorney, and representing you today is Mr. Zach Finling. With regards to the first case, 21 CR 006370F, you've been accused of 2 misdemeanor offenses, including simple battery. Are you aware of the other charge?
No, ma'am.
All right. Deputy, if you have the calendar, could you please show him the 2 charges for position number 11?
I don't have one. in front of
Oh,
me.
yeah, no, I do.
All right. The incident date is June 5th, 2021. Mr. Johnson, these are the 2 misdemeanor charges that have been brought against you allegedly in Fulton County, Georgia, and the prosecution will be trying this case. That will be the Solicitor General's office based upon the accusations they filed against you. Upon your entry of a not guilty plea to these 2 charges, the case will be scheduled for trial before the division judge. And during the course of that trial, the prosecution would have the complete burden to prove the 2 charges against you beyond a reasonable doubt and to overcome your legal presumption of innocence. If the prosecution does succeed, you could be convicted of each offense and be sentenced to up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Plead guilty.
No,
No.
Mr. Johnson, these were, when I went over the 2 different positions, these are the charges that you wanted to plead not guilty. And then the next one is the time served, no probation.
Oh, yeah, I plead not
This is
guilty.
the not guilty one.
I'll accept your not guilty plea, and this case has been arraigned and will be further noticed for trial. With regards to position number 12, Mr. Johnson, you will still remind you of your right to remain silent and your right to counsel. Your case number is 22 CR 002256F, in which you've been accused of misdemeanor obstruction of a law enforcement officer and violation of the rules regarding pedestrian in roadway. This is from an April 14th, 2022 incident, and also in Fulton County, Georgia. And I understand that this is going to be a negotiated plea. So for purposes of the plea, may I place you under oath?
Yes,
You solemnly swear the information you provide will be the truth to the best of your knowledge.
I do.
Mr. Walker, what is the recommendation?
Yes, Your Honor. The state's recommendation to both counts to run concurrently is a time serve offer. The defendant has been in custody on these charges for 15 days, balance suspended.
Mr. Finling, do we stipulate to the factual basis, venue, and ID?
Do you, Judge?
All right. Mr. Johnson, have you consumed any kind of medication or alcoholic beverages recently?
Ma'am.
And are you satisfied with the representation of your counsel?
Yes, ma'am.
Have you understood the proceedings so far?
Yes.
And is anyone forcing you to take a plea in this case?
No, ma'am.
If you enter a plea of guilty to these charges, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to have counsel help you challenge the state's case, confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of obstruction and 1 count of violation of the rules of pedestrian and roadway?
I plead guilty.
Your sentence is time served. That concludes this case. Thank you.
All right, next we have this is number 4 and 5, Mr. Ezzy.
This is Brian Ezett with 2 cases before the court. Mr. Ezett, you have a right to remain silent. Anything you say about the facts of these cases, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Finling. The first case is 20 CR 005851B. Mr. Ezra has been accused of simple battery domestic violence from a November 28th, 2020 incident. Second case is 22 CR 002261B. Mr. Ezra has been accused of misdemeanor obstruction of an officer in violation of the rules regarding pedestrian and roadway from an April 14th, 2022 incident. Mr. Ezra, for purposes of the plea, may I place you under oath? Raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes.
Right. Mr. Walker, what is the recommendation for both these cases?
Yes, Your Honor. The state's recommendation for position 4 is 12 months to serve, 64 days, credit for time served, 32 days, balance probated with the conditions of the completion of a family violence intervention program, a stay away from the incident location, which is 845 Ridge Avenue, apartment B, and no further contact with the victim, Ms. Aubriana Willis. On position 5, the state's recommendation is time served of 15 days, Your Honor.
All right, thank you. Mr. Findling?
Yes, Judge. For position 4, Mr. Ezra does agree to the recommendation. We would ask, he shares a child with Miss Willis. So he does not want contact with her, but they do share a child. So I guess there'll need to be like a third party transfer regarding their child. But he did agree to the FVIP as well, Judge.
And the location at Ridge Avenue, is that in Atlanta or another city?
Sorry?
Mr. Findling or Mr. Walker? If you know the Ridge Avenue.
I believe that is Atlanta, but I will have to confirm it.
Yeah, I would have to confirm too.
Is it Atlanta?
Yes, it's Atlanta, Georgia.
Okay, this can be. All right. Mr. Findling how old is the child?
The child is, I do not have down the age, Judge. How old is the child, Mr. Ezra?
3.
3.
Okay, 3 years old.
Turning 4 in August, yeah.
All right. And Mr. Ezra, are you married to Miss Willis?
No, ma'am.
Okay. And Mr. Findling, do you stipulate to the factual basis venue and ID
I do.
for both cases?
Yes, Judge.
All right. Mr. Ezra, I will allow you to have contact with the child, but you'll have to file a legitimation action in the Superior Court of Fulton County. All right. And then you'll need a court order to establish your paternity. Unless you acknowledge it, you will also need to establish your visitation and custodial rights with regards to the child.
I had to go to the Superior Court to do that.
Yes. You go to the self-help section. They have the forms there for you to file a legitimation action.
All right.
So there will be no contact with the child until you get a court order.
All right.
From Superior Court. Do you understand?
Yes, ma'am.
Okay. Do you still want to proceed with the plea?
Sure.
I'm sorry, did you say?
Yes.
Okay. So Mr. Azad, have you consumed any kind of medication or alcoholic beverages recently?
No.
And have you understood the proceedings so far?
Yes.
You understand that you'll be pleading guilty to 2 separate cases. Is that your?
Yes, ma'am.
Okay. And are you satisfied with the representation of Mr. Findling?
Yes.
If you decide to take a plea in both cases, you would have to give up your constitutional right to go back to court to have a trial in one or both the cases before a judge or a jury. You would also have to give up your right to have the assistance of counsel so that you could challenge the state's evidence, present your own defenses, to be able to confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to the 1 count of simple battery domestic violence?
I plead guilty.
Your sentence is 12 months to serve 64 days, credit for time served 32 days. If you have no other holds at the jail, you'll be released within 24 hours. Once you're released, do we have a good number on Mr. Ezzard?
Yes, I do, Judge.
All right.
I have his mom's number, and then he said once
Okay.
he gets a good number, he's relayed.
In that case, I will need, once he is released, he needs to report to probation at 132 Mitchell Street by next Tuesday, which is May 3rd, 2022. Do you understand, sir?
Yeah, ma'am.
Once you report to probation, they will have a probation case created. And on probation, you will complete a 6-month domestic violence intervention program at your expense. You will stay away, not return to 845 Ridge Avenue in Apartment E, Atlanta, Georgia. You are to have no contact. You do not have any contact whatsoever with Aubriana Willis. With regards to the child you share with Ms. Willis, you will have to file a separate legitimation action and get a superior court order to establish visitation and custodial rights. Do you understand, sir?
Yes.
Right. No contact with Ms. Willis means staying 200 yards away. Do not contact her in person, through a third party, through a phone, computer device, and also through social media. Understood? Your probation fees shall be waived for the first 6 months up to and including November 2022. With regards to the second case, how do you plead to 1 count of obstruction and 1 count of violation of the pedestrian rules and roadway?
Yes.
Your sentence is time served. That concludes that case. Thank you.
Position
Next, we
10,
got position
South End.
35, Your Honor. Position 35, Mr. Wimbush.
Position 10.
My goodness, we're competing over here. All right. Who has position 10 in South Annex?
And it says I have to go get another young lady from the floor, so I'm trying to get these 2 done. But position 10 is in front of you, Ms. Harris.
All right. South Annex, I'm going to take position 10 next. Courtroom 2, who do you have?
Position 35, Mr. Wimbush.
Okay. Michael Lewis Wimbush is accused of criminal trespass from July 23rd, 2021. Mr. Wimbush, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finling. Mr. Wimbush, for purposes.
Your Honor, I have Mr. Wimbush. I have that.
Oh, I'm sorry. Your attorney is Catrice Helen. With regards to position 35, I'm sorry, this is going to be a negotiated plea. Mr. Wimbush, may I place you under oath, please? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Webb, what's the recommendation?
Yes, Your Honor. The state is recommending 12 months to serve, 28 days, credit for time served, 14 days, balance suspended with a stay away from the City View Apartments at 265 Richardson Street, Southwest Atlanta. Nothing further, Your Honor.
Yes, Your Honor. That is our understanding of that plea. We do accept, we do stipulate to the factual basis, venue, and ID.
Thank you. Mr. Wimbush, have you consumed any kind of drugs or alcoholic beverages recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes,
Are you satisfied with your counsel?
I am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to plead guilty to criminal trespass, you would have to give up your right to go back to court, to have a trial in front of a judge or a jury, to be able to confront your accuser, examine witnesses, present your defenses, challenge the state's case, and have the state try to prove the charge against you beyond a reasonable doubt. Do you want to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass?
Yes.
Your sentence is time served. If you return to the City View Apartments at 265 Richardson Street, you will be arrested again. Understood?
Understood.
Do not return to that location. Best of luck. Thank you.
Thank you.
South Annex, who was your case?
Ms. Harris.
Position number
10. I'm sorry, ma'am. Position
No
10.
problem. Thank you.
And Judge, this will be an arraignment.
Okay. Ms. Shantidia Nicole Harris, case number 22 CR 002247C, is accused of theft by taking from December 3rd, 2020. With regards to this case, Ms. Harris, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and that will be Mr. Zach Finling. You've been accused of one count of theft by taking. Mr. Finling, do you waive a reading of the accusation?
I do, Judge.
Upon your entry of a not guilty plea, the case will be scheduled for a trial in the future. During the course of that trial, the prosecution has the sole burden to prove the charge against you beyond a reasonable doubt. If they prevail, you could be convicted and face a sentence of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Can I ask a question? I'm pleading not guilty in these cases, but I have two misdemeanor cases, and you're only speaking of one.
Yes, ma'am. Yeah, this was the accusation that I read to you, the theft by taking from December 2020, the
I
misdemeanor.
understand it. Yeah, I was trying to see, was it a misdemeanor case? I thought I was gonna have all my misdemeanor cases seen today.
So I'm showing 2 additional felony cases. I'm not sure if she's referring to those.
I have 2 misdemeanor cases. I mean, 1 felony and 1 misdemeanor case. The other one is probation.
All right. Ms. Johnson, let me just confirm. The case that we are addressing right now is a misdemeanor case.
Yes.
You have another case that's a felony case?
No, the other one is obstruction to officer.
I'm not asking you the charges. I'm just asking you, does the other one include a felony charge?
I think so.
That would be in Superior Court. I'm not addressing that case.
Okay.
And the third case you say is a matter on probation?
Yeah, that's probation.
All right. So that's a case in which you've already been convicted. So that wouldn't be on this calendar. So the only case I'm addressing is this one misdemeanor case for theft by taking from December 3rd, 2020, involving Church's Chicken at Old National Highway.
Okay.
All right. So given the information I've already said with regards to you entering a not guilty plea and the state having the burden of proof to prove the charge against you beyond a reasonable doubt and to overcome your legal presumption of innocence, and that if once we go to trial, if the state succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right. This case has been arraigned and will be scheduled for trial before the division judge. Anything else, Mr. Finley?
Nothing further. Thank you, Judge.
All right, thank you.
Oh, wow.
Next, we have position number 36, Your Honor. Mr. Youngblood, position number 36.
Thank you. James Youngblood Jr. is case number 22 CR 002241J, accused of public drunk on April 13, 2022. Mr. Youngblood has been advised of his right to remain silent, and his attorney is Patrice Helen. Mr. Youngblood, for purposes of this plea, may I place you under oath?
Sure.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Correct.
Thank you. Ms. Webb, what's the recommendation, please?
Yes, Your Honor. The state is recommended 12 months to serve 32 days, credit for time served 16 days, with the balance suspended, and a stay away from the MARTA North Springs Station located at 7010 Peachtree Dunwoody Road. Nothing further, Your Honor.
Ms. Helen?
Yes, Your Honor, that is our understanding of that plea. We do accept it. We stipulate to the factual basis, venue, and ID.
Mr. Youngblood, have you consumed any kind of medication or alcoholic beverages recently?
No, ma'am.
And have you understood the proceedings as they've been going on so far?
Yes, ma'am.
Have you understood and are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to take this plea and plead guilty to public drunk, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to be able to confront your accuser, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of public drunk?
Guilty.
Your sentence is time served. If you have no other holds at the jail, you should be released within 24 hours, and you cannot return to the North Springs MARTA station. So if you are on a MARTA train, just make sure that you disembark before the last stop on the northbound direction. Understood?
Yes, ma'am.
Thank you.
Thank you.
18, Mr. Phillips.
Position 33 and 34, Your Honor. Ms. Wheeler.
Ms. Helen, do you waive a reading of the accusations in both these cases?
Yes, Your Honor, I do.
All right. And is Ms. Kayla Wheeler, is she the one at South Annex?
Correct, Your Honor.
Okay. Ms. Kayla Wheeler has two cases, 19 CR 009-261A, in which she's accused of battery, domestic violence, and cruelty in the third degree. The second case is 19 CR 007-433A, in which she's accused of disorderly conduct from a March 9th, 2019 incident. With regards to both cases, Ms. Wheeler, you have a right to remain silent about the facts of the cases. Anything you say, your statements can and will be used against you. You have a right to an attorney, and representing you in both cases is Ms. Catrice Helen. We understand that you plan to enter a plea of not guilty to both these cases. These are misdemeanor offenses that have been brought against you, and upon your entry of a not guilty plea, your cases will be scheduled for trial in the future. At the time of the trial, the prosecution would have the complete burden to prove the charges against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, and if we can unmute South Annex. Deputy, could we unmute South Annex, please? Oh, was she good? Thank you.
I'm sorry.
That's okay, don't worry. Given this information, Ms. Wheeler, how do you plead to both these cases I've just mentioned?
Not guilty.
Your cases have been arraigned and there will be further notice for trial. Anything else, Ms. Helen?
Yes, Your Honor. This is a bond hearing today for Ms. Wheeler for both cases. She's 24 years old. She is currently working as being self-employed, a self-entrepreneur. For the last 20 years, Your Honor, she does have a one-year-old son who's currently living with her mother in Fulton County. Yes, she is originally from New York. However, she's been in Georgia for the last 10 years. Like I said, her mother currently lives in Fulton County, has been for the last 9 years. And so, Judge, I would also ask pretrial to read her history for me, please.
Ms. Harrison, good morning.
Good morning, Your Honor. I have 6 cycles. Last arrest was November 2019 for battery family violence, which is this case. I'm also showing an additional open case, felony for, one moment. Open felony 22 CP 208456, theft by shoplifting.
I'm
22
sorry. Yes.
CP 208456. GCIC indicates no convictions.
All right. Thank you. Anything else, Ms. Helen?
Yes, Your Honor. I wanted to hear her history because when I spoke to Ms. Wheeler, she assured me that, again, this is not the type of case or charges that she would even be accused of or involved of. This is not a history. This is not a part of her character, Judge. And specifically to go to the court, to the Ayala factors, she will appear for her court dates. I didn't hear any failure to appears again because this is not her kind of history. No witness intimidation. When I spoke to her, she hasn't spoken or seen or aware of these individuals that are listed here as the accusers in over 3.5 years, Your Honor. And as far as a danger to the community, as a 24-year-old, she selflessly volunteers for the 499 fridge, which is here in Georgia, has multiple locations. She also cleans her local neighborhood that she lives in. Again, Your Honor, I wanted to give that history to you and address those factors. And again, she's not going to reoffend based on that history. This is not a constant reoffender. We are asking for a signature bond for both cases, Your Honor. I'm not familiar if the judge or the court has the updated bonds. I did have a bond that there were no bonds, but currently I had the bond of the battery family violence at a 3,500 surety. Again, we're asking for a modification to a signature. And then the cruelty to the children in third degree, a $1,000 surety. We're asking for a modification to a signature bond. And then for the next case, the disorderly, a $1,000 surety. Again, Your Honor, we're asking for a modification to a signature bond.
Ms. Harrison, I've got a failure to appear on July 21st, 2021 before Judge Roth. Can we verify that?
I'm checking, Judge, one moment. I'm also showing 2018 disorderly conduct conviction.
That is correct. That conviction is out of Fulton County, and then she did FTA on this case.
She did 2022 April, which is this case.
And Your Honor, I also have an up-to-date address. I can't put it on record if you would like me to. For Ms. Wheeler, she is not aware of any failure to appears or not reporting to any court dates that she was meant to be at, especially with Judge J. Roth in July of last year, Your Honor. But I do have an up-to-date address as well as an up-to-date number, if you would like for me to give it in the chat or to the court.
And Your Honor, if I may respond as well.
Yes, just give me 1 second here, please. I just want to look up something. All right, you may proceed, Ms. Webb.
Yes, Your Honor. As you've heard and confirmed by pretrial, the defendant did FTA on these cases for the disorderly conduct in the battery in this year. And actually, this case did actually start the litigation process, Your Honor, as there was a motion to quash the accusation filed back in May of 2021. So that does give the court some type of indication that the defendant did have notice of these proceedings, Your Honor. A final plea was supposed to be entered on July of last year, on July 21st of 2021, in which the defendant failed to appear. It looks like she was again rescheduled for this upcoming calendar, for another calendar, excuse me, on April the 21st, in which she also failed to appear, Your Honor. So for those reasons, we are going to oppose any bond modifications. I did want to confirm the bond. I had a $2,500 bond due pretrial release. I do see that she does have a felony shoplifting hold from an incident that occurred on April the 22nd, and that is how she was picked up for these outstanding warrants on this present case, Your Honor.
Anything else, Ms. Ellen?
No, Your Honor, I'd like to just make sure I verified the bonds. What are the bonds again?
Presently, on the misdemeanor charges before us, there's no bond based upon the failure to appear. The felony theft by shoplifting allegedly occurring on April 21st is a $2,500 surety bond. Okay?
Understood, Judge.
All right. So on the disorderly conduct, it's going to be $1,000. On the battery, it's going to be $2,000, and the cruelty is going to be $500. If you can send me a modified bond order, Ms. Helen, email that to Katrina Lewis, and this will be surety bonds. All other remaining conditions stay in place, no further contact with the victim, and to stay away from the incident location with regards to the battery charge and with regards to the disorderly charge. No drugs, no alcohol, and no weapons. All right, and she's cases have been arranged, so it'll be further notice to Judge Roth's division.
Yes, we got position number 18, Mr. Phillips.
34 is $1,000 and 33 is 2,500 total. I beg your pardon, I'm sorry. 3 South, who do we have?
Number 18, Mr. Phillips.
18, thank you. Mr. Alfonso Phillips is accused of criminal trespass in 22 CR 002238G. Mr. Phillips, my name is Judge Law. You have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Findling. This is going to be a negotiated plea. So, Mr. Phillips, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes,
Thank you.
ma'am.
Mr. Walker, what's the recommendation?
Yes, Your Honor, it is time served. Defendant has been in custody 16 days, balance suspended with the condition of a stay away. That location is 1125 Ponce de Leon, located here in Atlanta, Georgia.
Is that the city market or the strip mall? What are we talking about?
Give me 1 second. Let me look it up. It appears that it is it's the Salvation Army.
Oh, okay. Nice. Yeah. All right. Mr. Finley?
Yes, Judge. We do agree to the recommendation and additionally stipulate the factual basis, venue, and ID.
Thank you. Mr. Phillips, have you consumed any kind of medication or alcohol recently?
No, ma'am, not recently, no.
Okay. Have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am. If it's okay with you, after we finish, can I speak to him for a minute? After we finish the case?
Okay, that's good. But just listen very carefully to my questions.
Yes, ma'am.
Is anyone forcing you to confess or to plead guilty?
No, ma'am.
And if you decide to confess and plead guilty, you would have to give up your right to go back to court, to have a trial, to be able to confront your accuser, examine witnesses, and have the prosecution try to prove the charge against you beyond a reasonable doubt. If you want to go ahead and plead guilty, you would have to give up these rights. Are you prepared to do so?
Yes, ma'am.
How do you plead to 1 count of criminal trespass at the Salvation Army?
I plead guilty, ma'am.
Your sentence is time served, and you cannot return to the Salvation Army at 1125 Ponce de Leon in Atlanta, Georgia.
Yes,
If
ma'am.
you are on the sidewalk or in the parking lot or in that office or in that building, you will be arrested again, and we get to do this all over again.
Yes, ma'am. I understand. Thank you, ma'am.
All right, thank you. That concludes this case.
I speak to my lawyer.
Mr. Findling will be able to speak to you later. I have to move on to my next case.
I'll talk to you later, Mr. Phillips. I can give you a call.
Peter, sir, I gotta give you that number, what me you discussed about yesterday.
Yes, sir. Yes,
Phone
I'm gonna
number
reach
to,
out to you.
Was she,
Yeah,
she
sir, if you
won't know.
could, sir, I recommend you, not say anything right now. I'll talk to you later.
All right,
Contact you.
Courtroom Two, Francois, who do we have, please?
Yes, good morning, Judge Law. This is going to be position 8, Mr. Gresham.
Thank you. We have Dennis Gresham, accused of criminal trespass and misdemeanor obstruction of an officer from December 29, 2021 in case 21 CR 008006Y. Mr. Gresham, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finling. For purposes of this plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? I can't hear you, Mr. Gresham. You need to speak up.
Yes.
Thank you, sir. Mr. Walker, what's the recommendation, please?
Yes, Your Honor, it's going to be a time served offer. The defendant has been in custody for 121 days.
Are there any other holds?
He does, Judge.
He does? Okay, we'll just keep it at that.
Okay.
Mr. Finling, do you stipulate to the factual basis, venue, and ID?
I do.
Thank you. Mr. Gresham, have you consumed any kind of medication, drugs, or alcohol recently?
No.
And have you, I'm sorry?
No, ma'am.
Okay, and have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney?
Yes.
And is anyone forcing you to take this plea today?
No.
If you decide to plead guilty to the two charges I've just listed, you would have to give up your constitutional rights to go back to court and have a trial, to be able to have the assistance of counsel to challenge the state's evidence, present your defenses, examine witnesses, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up your rights?
Yes. Yes, ma'am.
How do you plead to the two charges brought against you?
Guilty.
Your sentence is time served. Your obligations for this particular case are concluded. Thank you.
Next, we got position number 13, Mr. Marshall, position number 13.
State versus Shante Antoine Marshall, 19 CR 0068, excuse me, 000688B. Mr. Marshall has been accused of battery, public drunkenness, and battery in a public transit vehicle or station from a January 20th, 2019 incident. Mr. Marshall, you've been advised of your right to remain silent, and your attorney is going to be Mr. Zach Finling. With regards to this case, Mr. Finling, do you waive a reading of the accusation?
I do, Judge.
All right. Mr. Marshall, with regards to the charges brought against you, these are misdemeanor charges allegedly occurring in January 2019 in Fulton County, Georgia. Upon your entry of a not guilty plea, the case will then be scheduled for trial before the division judge, at which time the prosecutor has the complete burden to prove the charges against you beyond a reasonable doubt and to overcome your legal presumption of innocence. If the prosecution does succeed, you could be convicted of one or more of these offenses and face a sentence of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Information.
I'm sorry, sir. Could you repeat your response?
I thought this was for a signature bond.
Yeah, Mr. Marshall, we're gonna go over bond in a second. This is just you wanted to plead not guilty, so the judge is asking you how you plead, sir.
Oh, okay, yes, not guilty.
Mr. Marshall, are you pleading not guilty, and do you want a trial in these with regards to these charges?
Do I want a trial?
Yeah. Sir, yeah, Mr. Marshall, remember you made it clear to me that you wanted to plead not guilty. And once you plead not guilty, I'm gonna cover bond in a moment.
Okay, yeah.
So how are you pleading at the present time, Mr. Marshall?
Not guilty.
This case has been arraigned and it's going to be further notice for trial before the division judge. Ms. Harrison, may I have Mr. Marshall's GCIC, please? His
Yes.
position 13.
16 cycles. Last arrest was for the failure to appear on this case. Record indicates 2 prior failure to appear within the past 10 years. A 2010 theft by shoplifting. He has convictions beyond a 10-year period. Nothing further.
Thank you. Mr. Finley?
Yes, Judge. I am asking for a bond modification on behalf of Mr. Marshall. Mr. Marshall does have a $3,000 surety bond, looks like. He takes full responsibility for the FTA. At this time, he was getting his mail forwarded to a Dropbox to a church. He says it was sent 12 days before the court date, and he got it a couple of days after. He unequivocally would have been there if he got notice. He does have money, Judge, but he is unable to access that money, and he has no one that's able to help him bond out. So even if bond was $100, he would be unable to make it because he has no one that can help him. So that is why we are asking for a signature bond on behalf of Mr. Marshall. And as you heard, his criminal history is going years and years and years back. He's someone that's been walking a straight line for a while now. And that's why we're hoping for a signature bond on behalf of Mr. Marshall, Judge.
All right. And all the address we have on his system is not a good address. So what are we looking at right now?
Yes, so I do have a new address.
Is it another? What kind of address is it?
It's a mailbox.
You have the mailbox, and you gave me a good mailing address, and then you gave me a home address as well.
All right. Mr. Walker?
Yes, Your Honor. So the defendant started out with a signature bond, and he not only has one FTA on this case, he has two FTAs. So he's been given two different opportunities, starting with the signature bond. The first FTA was in front of Judge Porter. That was July 11th of 2019. And then he FTA'd again on a jury trial calendar of February 28, 2022. I feel as though a $3,000 surety bond based on his two prior FTAs and based upon the fact that he already had signature bonds on these charges, in addition to his other FTA on an unrelated case, a $3,000 surety bond is more than reasonable, Your Honor.
So I'm not sure how they
Mr. Marshall, I'd strongly advise you to not say anything. It can be used against you, sir.
Yeah,
I will speak for you.
it's fine if it's used against me. That's okay.
I couldn't understand you, sir.
I said it's okay if it's used against me. But I would like to speak about the FTA.
No, I would recommend you not, sir.
Okay, that's fine if you recommend it, but I would like to speak about it.
Whatever.
Okay, yeah.
You feel, sir.
Okay. When I was given the office, when I was told to report to the probation, they have a misdemeanor office and a felony office in the same building. So I kept reporting, and the case got reduced. So they said, we don't have your case. We don't have your case. I went back every week. The felony probation never got it because it was misdemeanor. So eventually, when I found out the information and that there was a misdemeanor case, I went and checked to the misdemeanor office, and then they said, oh, we have your case. So I was checking on the case weekly, but it was in a different office in the same building.
I'm afraid I don't understand. So you were reporting tomorrow on a felony probation case and you got confused about your misdemeanor cases?
No, when they sent me, not felony. They sent me to the public defender office. The public defender office had a felony and a misdemeanor. I went to the wrong office and I kept showing up. They said, we don't have a case on you. We don't have a case. I didn't know in that building had a misdemeanor and a felony office. So that's how the FTA happened originally.
Don't you have your case numbers?
Yeah, I had the case number and I was told.
And the public defender's office would then have directed you to the right location.
Right, but there are two offices in the building.
Okay, Mr. Marshall, first of all, the confusion and reporting to the public defender's office, I don't see how that is relevant to you not showing up in court twice in this particular case.
Okay, well, that I was just want to explain that, but if I can't get a signature bond, I'd rather plead guilty because I need to get back to work.
All right. You're not getting a signature bond.
Okay.
So
you want to speak to your attorney?
I would just like to plead guilty and maybe.
You would then need to speak to Mr. Finley.
Yeah, I'll need to speak with you, sir.
All right. We'll take the next case, please. And Mr. Finley, the number at the jail, you know it, right?
Yes, Judge.
Thank you.
All the other cases are Finley's, I believe, Your Honor.
All right. Mr. Marshall, please step aside and Mr. Finling will get in touch with you shortly.
Your Honor, for position 23, we have a couple of breakout cases. I know position 23 as well as the 3 cases that's on today's add-on calendar as well.
Right.
Yeah. So I could do my call during that.
Before I go on to the breakout cases, Courtroom 2, do I have anyone else who needs to be addressed that's not in a breakout?
Sorry, Your Honor, we was having internet problems.
Okay, I'm sorry. So I'm talking about, let me see, position 23, do you have John Claude Samir in the courtroom?
No, I already spoke to Mr. Finling about Mr. Samir earlier,
Okay,
and he said we were gonna reset him.
Can we reset?
all right. So position 23 is going to be reset.
Yeah.
All
So,
right.
and then Mr.
Before we move on, Mr. Finling, what date are you asking the case to be next Thursday or?
That was Miss Helen's case, but.
Oh, I'm sorry, Miss Helen?
Yeah.
I have, was this Miss Kim's case, Jay Kim's case?
Originally, yes, Your Honor.
Okay.
I'm not for sure if you recall this. It did come up on the C calendar about a week and a half ago. PD Kim was supposed to file. I do see in Odyssey where it was like a form filed, but I don't believe she actually filed an order for signature for that MH evaluation.
I'm resetting it to the competency calendar on May 12th.
Thank you, Your Honor.
That'll be fine.
Judge.
That's what position 23.
23, okay. All right, then we have the add-on calendar. Okay, I don't think you have Anne Mcgee.
I also have position number 16, which is a.
We have left position 16 and 17.
So you have position 16 and 17 in Courtroom 2, correct?
That is correct, Your Honor.
All right, let's go ahead and. Oh, okay. So let's go ahead and address position 16.
Okay,
Christopher
Good morning.
Osterloo. Did I pull a wire or something? Oh, okay. All right. Mr. Osterloo is case number 11 CR 367392, accused of DUI less safe, DUI per se, speeding, reckless driving, and failure to maintain lane from June 5th, 2010. Mr. Osterloo, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finling. This is going to be a, all right, tell me what's the announcement for position 16?
Yes, Judge. This is going to be a bond hearing, jail jury bond hearing.
And he's going to enter a plea of not guilty to a 2010 case?
He made it clear to me he did want to plead.
He wants to
not
challenge it in the trial?
He does want to challenge it, yes, Judge.
Okay.
And he was, yeah.
Was there a plea offer from the state?
It was, Your Honor. It was a statutory minimums. Despite the defendant's lengthy driver history, but I will save that for later.
Okay, all right. So in that respect, do you waive a reading of the accusations, Mr. Finley?
I do, Judge.
All right. So Mr. Osterloo, as I said, these charges arise from a incident from June 5th, 2010, with regards to the misdemeanor offenses I've just listed. Upon your entry of a not guilty plea, the case will be scheduled for trial before the division judge. And during the course of that trial, the prosecutor would have the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecution does succeed and they do overcome your legal presumption of innocence, you could be convicted of one or more of these offenses and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead? Please unmute Courtroom 2.
Your Honor, I would take a disposition that the statute of limitations is up on this charge. I've been incarcerated for 8 years, on and off. The FTA that I have proof right here.
Yeah.
This is at
Mr. Osterloo, I'm going to speak for you shortly, but I'd strongly recommend right now.
But, hey, yes, Your Honor, I'm definitely not taking anything for this charge.
Statute of limitations is not applicable. So, anything else?
Sir, I'm gonna speak for you, Mr. Osterloo. from what
Anything
we
else,
talked
Mr.
about.
Finley?
I do want to speak regarding bond.
This is an active criminal DUI case against Mr. Osterloo. So, and he's pleading not guilty. The case has been arraigned and is further notice for trial.
And I just want to cover bond whenever you're ready, ma'am.
Yes, I'm ready. So we're going to begin with Ms. Harrison. Ms. Harrison, we are addressing Christopher Osterloo.
Yes, Judge, 7 cycles. Last arrest is the FTA. One moment. It shows an open probation in Gwinnett County for interference with government property, theft by taking and burglary 2nd degree, sentenced September of 2020, 3 years confinement and a 5-year probation. Prior to that, there is a one second. There was a 2018 DUI in Forsyth County. It was dismissed. A 2019 criminal trespass and simple assault conviction in Hall County. 3 or more violations of probation and 1 failure to appear within the past 10 years. He has a 2017 in Gwinnett County theft by taking conviction, 5 years probation, May of 2017.
Was that part of the open probation case you just initially mentioned?
No, Judge.
Okay.
This one was 2016.
Oh, I see. Okay.
A 2015 theft by receiving stolen property and fleeing or attempting to elude, Rockdale County. A 2000 and one moment, 2000. It appears to be a 2014 Rockdale County DUI. It was amended to DUI under the influence. Originally, it was, doesn't indicate what it was prior in the GCIC.
Okay.
Oh, it's DUI under multiple substances, but it was reduced to DUI.
And that was in 2014?
Correct, in Rockdale County.
Is there a 2013 Fulton County DUI as well?
One moment. There was, and it was, I'm showing it as a failure to appear in 2013.
All right.
Let me go a little further back.
No, that's good. Appreciate it. Thank you. Mr. Walker?
Yes, Your Honor. The defendant has an 8,300.
I'm so sorry. I'm so sorry. It should have been Mr. Finley first. Sorry about that. Sorry. Mr. Finley?
Yes, Judge. I am asking for a bond modification on behalf of Mr. Osterloo. As you can see, this case does arise from an incident that occurred on May 5th, 2010. Mr. Osterloo is a veteran. He was in the military active duty for 4 years, U.S. Army as a paratrooper. Judge, he has been incarcerated on and off for the last 8 years. According to him, it's been a matter of about 6 months put together that he has been free. Most recently, he has been incarcerated for close to 3 years straight up until now, according to him. And that would mean he's spent, close to 900 or so days straight sitting in jail. He has a 17-year-old daughter that graduates high school next month. He's hoping to get to her graduation. Judge, he has no money. And as we can all imagine, being incarcerated for that long, you can't make money when you're sitting in a cell. So it might as well, the $8,300 bond might as well be $83,000 because he just has zero chance to pay that. That is why, on behalf of Mr. Osterloo, he wants to fight this. So I hope he can fight this from the outside. I'm asking for a signature bond on behalf of Mr. Osterloo, and if not, a surety bond not exceeding $1,000.
All right. And it's an 8304 cash bond, according to what I see here. All right, Mr. Walker.
Yes, Your Honor. I know that there is an $8,000 cash bond, but that is definitely with reason. Outside of the 2 additional DUIs that was mentioned by pretrial, I'd like to bring to the court's attention that he has 2 previous FTAs on this particular case. He has a very extensive driver history. This individual is a very dangerous individual on the road. I would just go back through his driver history from 2010 going up to 2019. I have an improper lane conviction, a seatbelt conviction, 1 felony fleeing conviction, 3 different reckless driving convictions, 2 Georgia major lifetime commercial violation convictions, and 3 suspended license violations, along with 3 additional FTAs outside of this case. That is why the defendant has an $8,000 cash bond. Again, he is a very dangerous individual on the road. I understand that counsel states that he's only been out of jail for 6 months. If that is true, it's very concerning because that means he's racked up all of these charges that I just mentioned in a matter of months. So I would ask that the bond remains in place and that a reduction is not granted.
All right.
And if I may, Judge.
Yes.
Yes, Judge. Mr. Osterloo also wanted me to point out that he does have proof of incarceration documents that he showed me. I fully recognize that he does have missed court dates. He assures me that some of those missed court dates were because he was incarcerated. So that's just wanted to say that in regards to those FTAs, Judge.
Your Honor, the deputies here looking at the FTAs that I had from 2014 on this case. I was incarcerated there in Rockdale County. I did file a motion of detainer for disposition on the case. I do have a copy of that. It is at the house. But like I said, in 2019, I was reincarcerated on probation violation in Gwinnett County. I've been currently incarcerated now for 37 months straight. The DUIs that was mentioned by the state, all of those DUIs were dismissed. The DUI 2013 is the same case as this. I've only had 2 DUI charges in my life. I've never had a DUI conviction. I understand that does not hold weight as far as what we got in disposition.
Mr. Osterloo, can I finish? I'll argue for you, sir.
Well, if he wants to argue for himself, that's entitled, he's entitled to do so. But if he wants to, but that only means that he's going to have to waive his right to remain silent, and anything he says can and will be used against him.
That's fine, Your Honor.
Proceed, sir.
I don't dispute the state's accusations that I've had issues with law enforcement in the past. I have records here that the deputy can verify as well as these proof of incarcerations. I am a military vet. I suffer from PTSD. I was shot 3 times while in the military.
Mr. Osterloo, I'm going to ask you one question.
Yes, ma'am.
What does the fact that you served time have to do with the 2010 DUI case?
Your Honor, the only thing is that I believe I have a right to fight this case in trial, which I do. I've been incarcerated this entire time. Like I said, from Rockdale County, I filed a motion of disposition on this case. I was never picked up by Fulton County and brought before the courts for a transparent. I do believe this failure to appear occurred in August of 2014. I have proof here for where I was incarcerated in Rockdale from April of 2014 continuously to 2016, which I was released in 2016. And I was reincarcerated with a failure to, or not reincarcerated on a probation violation in Gwinnett County, which I have proof of incarceration on that as well.
I don't need your proof of incarceration. I just need to know what does the fact that you were in jail have to do with the 2010 DUI?
The fact is, I just I would like to continue fighting this case in the court of law, as is my constitutional right.
I agree.
The only thing I'm asking of the court is in lay of all of this, I've been incarcerated for 37 months.
Understood.
My daughter's about to graduate. I posted bond on this case originally. I did have a failure to appear on which I was incarcerated on and was given a signature bond on that failure to appear.
And now you are going to listen to me.
Yes, ma'am.
Ayala factors, state versus Ayala, qualifies a person for a bond or a signature bond if they are not a threat to themselves, to others, or to the community.
Yes, ma'am.
Ayala factors also allow me to consider the fact as to whether you show a very reasonably high propensity to reoffend. And just listening to your criminal history record from 2010 all the way until the time that you spent the last 3 years incarcerated indicates to me that you've had run-ins with the law consistently almost every year. I don't know whether to feel sorry for you or to feel sorry for your 17-year-old daughter, but you have not been a stellar example of a parent.
Right.
Okay, so then the fact that you have a right to defend yourself and a right to assist your attorney in your defense doesn't qualify you for a signature bond, given this increasingly history and a very high likelihood to reoffend. I have no problem keeping the same cash bond. It is representative of your current situation. But in reviewing the case, the age of the case, and the nature of the charges, your bond is going to be modified as follows. With the DUI alcohol less safe, that's going to be $1,000 surety bond. With the DUI alcohol per se, that's going to be a $3,000 cash bond only. With the speeding, that's going to be $1,000 surety. The reckless driving, $1,000 surety. Failure to maintain lane, $1,000 surety.
Can I go ahead and just take the state's offer today, Your Honor?
That's going to be a 1, 2, 3, and 4, $4,000 surety bond and a $3,000 cash bond only. No driving at all until he goes to trial and there's a resolution in this case. No alcohol, no drugs, and no weapons. I can reset this case on next Thursday. And we all can to reconsider a possible plea. Thank you.
Thank you, Judge. And Judge, if you don't mind, could you go through really quick?
The DUI per se is a $3,000 cash bond only. All the other charges is $1,000 surety.
Okay.
No driving. I don't care whether he's got a valid driver's license right now.
Well, a valid driver's license with a clean driving record. Everything the state said was a lie. That's the complete.
Do not interrupt, Mr. Osalu.
I don't care. You guys are keeping the man.
All right, Mr. Finley, the bond modification is off the table. Just keeps with the same bond. We'll see him next week for the possible plea.
Understood. Thank you, Judge.
That's May 5th. Okay. All right, next case, Courtroom Two.
Position 17, Mr. Pendergrass.
Okay. Position 17 is going to be William Hillary Patrick Pendergrass, accused of theft by taking from December 4th, 2018. Mr. Pendergrass, you've been advised of your right to remain silent. Your attorney is going to be Mr. Finley. For purposes of your plea, may I place you under oath?
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Walker, what's your recommendation?
Yes, Your Honor. The state's recommendation is 12 months to serve, 16 days, credit for time served, 8 days, balance probated with the conditions of a theft diversion or a theft prevention class, a stay away from the incident location, which is 10975 State Bridge Road, which is a McDonald's, and $100 in restitution.
Thank you. Mr. Finley?
Yes, Judge. We do agree to the state's recommendation involving the class and the restitution. We would just ask that once he does complete that class and does pay the restitution, if his probation could be terminated or not reporting, Judge.
Any objection to termination upon
No
payment of
objection.
restitution?
No
Okay,
objection.
thank you. Mr. Pendergrass, and we stipulate to factual basis venue and ID. Yes, Mr. Finley?
I do, Judge.
Thank you. Mr. Pendergrass, have you consumed any alcohol or medication recently?
No.
And have you understood the proceedings so far?
Yes.
If you decide to take this plea, you understand that you have to give up your constitutional rights to go back to court, to have a trial before a judge or a jury, to be able to have the assistance of counsel, to challenge the state's evidence, present your own defenses, be able to examine witnesses and confront your accuser, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Is anyone forcing you to take a plea today?
No.
How do you plead to one count of theft by taking?
Guilty.
Your sentence is 12 months to serve 16 days, credit for time served 8 days. If you have no other holds, you'll be released from the jail within 24 hours. You'll report to, do we have a good address and phone number on you?
I do have a good address and phone number, Judge.
All right, then probation will contact you. I'm assuming it's a mobile phone, right?
Yes.
Probation will contact you on that phone number as well as text you information as to when to report to probation. Do you understand, sir?
Yes.
And while you're on probation, you will complete an anti-theft class at your expense, and you will pay off restitution of $100, and that payment will be made directly to probation. At all times, you cannot return to the McDonald's restaurant at 10975 State Bridge Road in, I think it's Alpharetta, Georgia. Do you understand, sir?
I do.
All right, I'm going to waive your probation fees for the months of May, June, and July. If you complete the restitution and the class during the next 3 months, then your probation will terminate. But if you still haven't completed it, you will continue to report to probation and start paying probation fees from August 1st onwards.
Okay. Yes, ma'am.
Thank you.
May I ask who the restitution going to?
Oh, yes.
Or they can type it in the chat or email it, Mr.
Mr. Walker, who's the victim who's receiving the restitution?
To McDonald's.
Well, we'll just make it to the McDonald's manager at 10975 State Bridge Road, Alpharetta.
Everybody else?
Is there anyone else who needs to be addressed in courtroom 2?
No, that's it.
I believe I just had to speak to one of my clients while the breakout room was happening, Judge.
Francois, there was one other person that Mr. Finley needs to speak to.
Okay.
Thank you.
Your Honor, South Annex had an add-on, a Miss McGee, Anne
Yes.
McGee.
South Annex, are you present?
Mr. Finley, did you need to talk to him on the phone or you need to?
Phone.
Yeah,
Phone.
yes. If
Okay.
I could phone him, please.
Yeah.
You can call.
Okay, 2392, right?
Yeah.
Yes.
I think he's a copy of the add-on calendar.
Yeah. I don't see South Annex on. Oh, there it is. Okay. We have State versus Anne McGee, position 1 and 2. Is this the breakout matter?
Yes, Your Honor.
Okay. Ms. McGee, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Ms. Catrice Helen. Will the breakout matter involve Ms. McGee herself or just counsel and myself?
Just counsel at the moment, Judge.
All right. Will the host please place Mr. Walker, Mr. Howard, myself, Ms. Helen, and Ms. Webb in a breakout room, please?
And Ms. Burgess as well, Judge.
Oh, I'm sorry, Ms. Burgess. I did see her on the screen earlier.
Yes.
Okay. All right, we are going to address Miss Anne Mcgee at the South Annex. All right, Miss Mcgee, your attorney, Catrice Helen, is going to be speaking with you. So, Katrina, could you please place Miss Helen and South Annex in a breakout room?
Thank you, Judge.
All right, and with regards to position number 3 on the add-on calendar, State versus Cortez McWarther, we're going to reset that to June 9th, pending an evaluation to the competency calendar. Position number 3, just at the add-on, it's going to be reset to the competency calendar on June 9th, pending an evaluation. All right, do I have Markeisha Lester present? Markeisha Lester? Ms. Armstrong?
Yes, Judge, Ms. Lester is present.
Yeah, I'm trying to.
I'm here, Judge. Good morning.
Good morning, Ms. Lester. You have to appear via video. Yeah.
I'm really trying to get it. I'm trying to get on. Okay. Okay.
All right, thank you. This is the bench warrant request to set it aside, bench warrant calendar with State versus Markeisha Lester, case number 21 CR 002431D. Ms. Lester was accused of battery domestic violence on May 18th, 2021 incident. Ms. Lester, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Public Defense Counsel, Ms. Sarah Armstrong. This was a failure to appear on January 24th, 2022. And the motion to set aside the bench warrant was filed on April 21st, 2022. All right, Ms. Armstrong, what is the reason to set it aside?
Yes, Judge, thank you. Ms. Lester was ordered to not return to the address where her son resides. Her son is the co-defendant. They both were arrested pursuant to this incident. So she had to find alternative housing. And unfortunately, there was a miscommunication about updating her address with the court. So her address has been updated with the court. So she's receiving notice at the address provided. She's retained counsel. Of course, that is me. We are in constant communication about her case. And while it's not necessarily related to why the bench warrant should be set aside, I think Your Honor should know that the co-defendant, which is her son, his attorney filed a Fifth Amendment affidavit. Ms. Lester has also filed a Fifth Amendment affidavit, and this is a case where the only witnesses were the co-defendants. So in the interest of justice, we would also ask Your Honor to set aside the bench warrant given the state's limited capacity to proceed with the prosecution in this matter.
Thank you. Mr. Walker, or is that?
It's my case. The state's position is the defendant had the responsibility to update her address with the clerk. That did not happen. As you're aware, she did have an FTA from earlier this year. I did review her history. She does have a previous family violence conviction, so this is not her first DV case or her first rodeo. With that being said, she initially was granted a signature bond. It's my opinion that she's not entitled to a second bite of the apple as far as getting a second signature bond. I asked that the bench warrant remain, and she remains herself into custody, Your Honor.
Did she was on a signature bond through the jail or through pretrial?
So it doesn't specify. I just see that it was a $5,000 signature bond. I'm not sure if pretrial is on the line, but per Odyssey, it says $5,000 signature bond.
Was signature bond through the jail? Okay.
And Judge, the address has been updated once again. And I also want to point out that Ms. Lester is indigent and she's not able to work at this time because of the bench warrant. She's absolutely terrified of leaving the house. So once again, this case cannot go far with the.
I'm sorry, terrified of what other than?
Leaving the house because she has this bench warrant, and we were asking Your Honor to lift the bench warrant so she can continue working.
All right. did receive the benefit of a signature bond through jail. I do understand this is a cross-dependent case, but I do find that this is a failure to appear. I'm going to cancel the bond forfeiture calendar. I think she has it before Judge Edline.
Yes, and the co-defendant has a bench trial scheduled very soon.
All right. She will need to report to the Fulton County Jail, and her bond is going to be a $3,000 signature bond through pretrial services.
Okay, thank
She
you.
will report to pretrial. She's to have no further violent contact with the cross-defendant, no illegal drugs, no alcohol, no weapons. And she will complete a 4-week anger management program while she's out on a signature bond at her expense. She can do it in Milledgeville, or she can do it in Atlanta, wherever she likes. So Miss Markeisha Lynn, you would have to come to the Fulton County Jail, be booked in, and be re-released on a signature bond through pretrial services. Do you understand?
Let me just, okay, yes, ma'am, I understand.
And we'll speak, Ms. Lynn.
All right, and she'll have to report to pretrial once a month. No illegal drugs, no alcohol, no weapons. And while you are on a pretrial bond, you will attend and complete a 4-week anger management class at your expense. Do you understand?
Yes, ma'am. I'm sorry.
And every time that you report to pretrial, you will let them know the progress of your anger management classes.
Okay, so do I get another court date, Judge, or is this just?
We will send you your next court date to your address, which we have presently listed as somewhere in Milledgeville.
Yes.
Do you have a new address?
The one
See a
in
Randall
Milledgeville.
Drive?
Yes, ma'am.
Do you see?
That Randall Drive is the one.
Yes, ma'am.
All right. I'll allow her to do telephonic reporting to pretrial, unless she doesn't mind driving from Milledgeville.
Pre-trial, I gotta come to Atlanta?
Yes.
Okay, and you said once a week?
Once a month.
Oh, once a month, okay. I
But
can do that.
your first visit must be in Atlanta, and then after that, I will allow for telephonic reporting as long as you show good progress with your anger management classes.
Okay.
All right. Ms. Armstrong, you sent a message to Katrina on the chat. Did you have? I'm not understanding.
The terms that the court ordered were listed a little quickly, and I just needed that written out for me so I could put that in the order.
Okay, let's go ahead. It's 3,000 signature bond through the jail. Through pretrial. It's a modified bond order. No further violent contact with the cross defendant. No alcohol, no illegal drugs, no weapons, no firearms. She will report to pretrial once a month. She will complete a 4-week anger management program at her expense and report to pretrial with regards to her progress on those anger management classes. Her first appointment with pretrial must be in Atlanta. After that, her appointments can be through telephonic means since she lives in Milledgeville. Her next court date will be sent to her at her current mailing address. I'm assuming that's the Randall Drive. If she changes her address, the first person that should find out about her new change of address is, of course, the court clerk's office.
I will send an order shortly.
All right, and Ms. Lynn, today is Thursday. You must surrender to the Fulton County Jail by May 2nd, which is a Monday, by noon. this coming Monday.
Okay. Thank you, Judge. I will.
So you can do it anytime between now and May 2nd.
Okay, so I can get a signature bond and I can be out. I can go back to work so I can attend to these classes that I have to pay for. Is that correct?
That is correct. But your first interview will have to be with pretrial at the jail.
Okay.
Ms.
So
Harrison,
I will have
can that be worked out if she surrenders anytime before Monday?
Yes, Judge.
Okay.
I do have to ask
So-
if there's any potential impact that the road closures could have on Monday in the 3rd, with meeting with pretrial. Just want to double check that.
So definitely do it before Monday.
Yes.
Oh, this is at Wright Street, so the road closures shouldn't affect. The road closures are all the ones leading to the jail, to the courthouse.
Right. It's just in terms of pretrial and their ability to meet. I had to throw that out there. Just advocating, I had to ask.
They all meet at the Wright Street facility.
Okay.
Okay?
Okay, thanks. So once I get there, I can sign my own bond and I can get back out.
Right. But if you get arrested again, or if you don't show up in court, or if you don't report to pretrial, and you don't show reasonable progress with your anger management classes, like you completely ignore it, pretrial has the authority to revoke that signature bond, and you'll be arrested again.
Okay, so right now I still have the FTA, the
The
warrant.
bench warrant is still until you surrender yourself to the jail.
Okay.
And the modified bond order, as soon as Ms. Armstrong gets it to us, the sooner we can file it.
Okay.
It will be ASAP.
Okay, thank you, Ms. Lynn. You're free to go.
Okay, thank you, Judge. Thank you.
Thank you. That concludes my business. May I be excused?
Oh, wait, just one second, just one second. State versus Cameron Williams. Is Cameron Williams present?
Yes, ma'am.
All right. This is State versus Cameron Williams, case number 21 CR 005536H. Ms. Williams is accused of battery, domestic violence, and battery from October 14, 2021. Ms. Williams, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney if you cannot afford one, and you financially qualify for the services of the Public Defender's Office, one could be appointed to represent you. Do you have an attorney?
I do. I forgot his name.
Well, that's not good.
I know. Give me one moment. I'm so sorry.
Why is he in the courtroom?
I don't know. Drew Fondling.
Your attorney is Drew
No.
Finley?
Findling.
No, did my name pop up on your phone? As 'cause I
Yes.
tried to get a hold of you.
Oh yes, I talked to somebody last night. I thought it was you. You sound exactly like the
Yes,
person.
ma'am. Yeah, that's it.
Well, you definitely don't sound like Drew Finling, Zach Finling, so.
Oh, well, probably over the phone. I thought it was. Oh,
Okay, thank you. Ms. Armstrong, you're free to go. Thank you. All right, your attorney is Mr. Zach Finling.
That is me.
I think Mr. Finling is 6 feet tall and over, and definitely not Mr. Drew Finling. Okay.
I'm a little bit taller.
All right, so moving on with regards to Ms. Williams. Ms. Williams, you filed a request to set aside your bench warrant. The bench warrant was issued on April 1st, 2022 for failure to appear for the arraignment calendar before Judge Taylor on March 31st, 2022. Presently, I see that proof of incarceration was filed with the court, indicating that you were allegedly in the DeKalb County Jail, and that you were, it says the detainee was released. When was she released? There's a blank.
I believe she was released. And correct me if I'm wrong. It's January 10th, 2022.
Yes.
All right. Ms. Webb or Mr. Walker, who's prosecuting?
This is my case, Your Honor. I'll be representing for the state.
Are you satisfied that Miss Cameron Williams was otherwise detained in DeKalb County at the time that she was supposed to report to Judge Taylor?
Yes, Your Honor, if Mr. Finley can just shoot me a copy of that, just to have it, because I don't have it copied into Odyssey.
You don't? I'm looking at it. No?
It's not showing up on my end on the Discovery tab. I can only see, I don't see anything filed since last year.
Okay. It was filed with Odyssey on April 20th, 2022. Mr. Finley, if you'd like to send it to Ms. Webb. In that respect, any objection to me setting aside the bench warrant?
No objection, Your Honor. And the state has made an offer as well on Ms. Williams' case.
All right. Mr. Finley, did you want to confer about the offer now?
Sorry, it cut out for a second. Can you repeat that?
Do you want to confer about the offer right now?
Sure. Yeah, that's fine.
All right. Do you have the offer, Mr. Finley?
I don't, I do not have an offer.
All right. Can we place Ms. Cameron Williams, Mr. Zach Finley, and ASG Webb in a breakout room to discuss this possible offer? And then Ms. Webb, you can leave the breakout room if Mr. Finley and his client want to talk, okay?
Okay, thank you.
All right. Let me see. Francois at the Courtroom Two. Courtroom Two. All right. While we're waiting for them, Mr. Walker and Miss Helen, Patrice Helen, let's just go over. Anyone present?
I'm here, Your Honor.
Still in the breakout room, Mr. Howard and the client. And you just put Mr. Finley in the breakout room, so there's nobody available. There's no PD right now.
What's Miss Helen doing in the breakout room?
She was talking to the individual from
Miss McGee?
Yeah, Miss McGee.
Ask them, are they ready to, we're ready to proceed. We need one of them out here.
Hello, y'all. This is Katrina. The judge will know if we need one of the PDs out in the main session.
All right, Mr. Howard, I just wanted to go, and Miss Helen, are we ready to proceed with the plea on Anne McGee?
Judge,
Oh, go ahead.
Your Honor, we're going to actually request that it be reset to Tuesday.
Okay.
For May 3rd.
I'm actually going to reset it to next Thursday.
Well, Judge, we didn't want to go that far out. We just need to get the appointment and we can do that by Tuesday.
Okay.
Right. So that's why we're asking for Tuesday.
All right. Please let Judge Morrow know that y'all requested it and I didn't. Okay.
Yes, Your Honor.
Reset to May 4th for plea.
Is it the 4th?
May 3rd, excuse me, May 3rd.
Remember, there's going to be an add-on counter, so I have to do an add-on counter.
Okay, this is going to be put on the add-on calendar, all right?
Okay.
Understood. And I think, Ms. McGee, we will see you next Tuesday and hopefully they worked out all the details and you should be well on your way, okay? All right, we'll see you then. Thank you, South Annex. We concluded with South Annex.
Yes, ma'am. Thank you, Your Honor.
No problem. Courtroom 2, we have one other person and we are waiting for Mr. Finley. I didn't know whether this want to proceed with the plea. So let's just go down the calendar right now. On the state all-purpose add-on calendar, Anne McGee, position 1 and 2 is reset to May 3rd for the add-on plea. Position 3 is reset to June 9th, pending an evaluation. That's going on the competency calendar. With regards to the DV bench warrant calendar, position number 1, the bench warrant will be executed and Ms. Lester will surrender herself to the jail and there will be a modified signature bond on file. after she surrenders by Monday, May 2nd. And position number 2, Cameron Williams is discussing a possible plea right now with counsel, Mr. Zach Finley. With regards to the all-purpose calendar, position number 1, John Bryant has filed a waiver of arraignment, so that case is further notice for trial. Position number 2 was a plea. Position number 3 is reset to May 19th. Position number 4 was a plea. Position 5 is a plea. Position 6 and 7 are pleas. Position 8 is a plea. Position 9, Christopher Harris is reset to competency calendar. What date? Mr. Howard? Did we lose Mr. Howard?
No, he's there.
Which position, Judge?
Position 9, Christopher Harris.
Oh, Judge, since we're gonna be doing, I would say that June the
June
9th
9th.
date, yes.
Okay. Position number 10 is arraigned and further notice. Position number 11 is arraigned and further notice for trial. Position 12 was a plea. Position 13 is arraigned and further notice. 14 was a plea. 15, position 15 is reset to May 12th. Position 16 is reset to May 5th for a possible plea. There is no bond modification in position 16. Position 17 is a plea. Position 18 is a plea. Position 19, Gabriel Resto. 19, 20, and 21, Mr. Resto. Excuse me, position 19, 20, Mr. Resto was released. Position 21, Chastity Riddick was released. Position 22 is a waiver of arraignment for the notice for trial. Position 23 is reset to May 12th competency calendar. Position 24 was a plea. Position 25 is a plea. 26, Barry Smith is a waiver of arraignment has been filed, further notice for trial. Position 27 was a plea. 28 was a plea. 29, 30, 31, and 32, Mr. Craig Washington are reset to May 5th. Is this going to be to the competency calendar?
No, Your Honor, it was just a medical reset to the SAP calendar.
SAP calendar, May 5th. Position 33, Kayla Wheeler is arraigned and further notice for trial with a bond modification. Position 34 is arraigned and further notice for trial, bond modification. 35 is a plea, 36 is a plea. So I don't know if we are waiting on anyone in courtroom 2. Courtroom 2. I don't think anyone's present, so Mr. Findling may have reset that one case he had for a possible plea. All right, we're just going to.
Please remind them, I do not have the waivers for the reset for jail jury. So PDs, can you please make sure you file that information with me today? Along with your paperwork that comes in for the plea.
Okay, Mr. Howard, I don't see Miss Helen. Miss Helen? If you have any of your clients who have filed a waiver of arraignment, please make sure the copies are directed straight to Katrina Lewis, hopefully before 1 o'clock today. And please pass a message along to Mr. Findling as well.
Thank you, Your Honor.
Okay. Mr. Findling is still in consult with Miss Cameron Williams. So maybe go into a breakout room with Mr. Walker, Mr. Howard, Ms. Burgess, with regards to our competency calendar.
I should be able to join back last one.
Okay. All right, Mr. Findling, you had one other case waiting in courtroom 2. You had a conversation with him. So we're going to reset that case. That was an arraignment and further notice for trial. He wanted to discuss a possible plea.
Yes, that was is that Mr. Marshall?
Yes.
Yeah, Mr. Marshall, he does want to take a plea, Judge.
Is that today?
If he's able to today.
Courtroom 2 is not responding, so I don't know. He was originally arraigned and further notice
Yeah.
for trial.
Yeah, it was, and then he
Would he need to do extra time?
Sorry, Judge.
Would he have to do extra time?
Yeah, so it does have him down for, yeah, they have him down for the 15 additional days.
Okay,
I
so
was-
I'm gonna reset him to Thursday,
Okay,
May 5th, SAP calendar, and that additional time will count towards the plea.
okay, sounds good, Judge. Thank
All
you.
right. So position 13 is reset to May 5th for a possible plea. And that should conclude the SAP calendar at Courtroom 2. So if anybody's listening, Courtroom 2, we are done with SAP. Okay, we're going to, Mr. Finling, if you have filed waivers of arraignment for any of your cases, please submit your waivers directly to Ms. Katrina Lewis before 1 o'clock today.
Okay,
All right.
will do.
That leaves us with our competency. I have a
Oh, I just have, I
Yes.
just talked, I'm sorry, Judge, I just spoke with,
Cameron Williams.
this one, yes. And she does want to take that plea.
All right, get the paperwork together and submit that to Katrina Lewis, and I will take a plea after I come back from the competency announcements.
Okay,
All right. Ms. Lewis, if you could place Mr. Walker, Mr. Howard, Ms. Burgess, and myself in a breakout room. Anyone else?
Everybody should be able to accept the breakout room that you were just recently in. Let's go right back into it.
This meeting is being recorded.
Oh, okay, okay. I don't know what's going on. This ain't here. I don't know. They're probably in a breakout room because usually they just pop up here, but this will
hey, Ms. Williams. Hey,
sorry.
they're handling another couple cases. They'll be back in in a little bit, okay?
Okay.
So just,
Do
so
I
just,
just turn off my camera or?
yeah, you can do that. Just, you can turn off your camera and mute yourself, but just, have the sound on so you can hear when they come back.
Okay. All right.
All right, thank you.
No problem. Thank you.
No worries.
A report on the 11 o'clock competency calendar. Positions 1 and 2 are going to be reset to June 9th pending evaluation. Position 3 is going to be reset to May 12th pending transfer from Cobb. Position 4 is reset to May 19th pending status of evaluation report. Same announcement for position 5 and 6. Position 7 is reset to June 2nd pending an update. Position 8 is going to be reset to May 5th tentatively. Hopefully she will be released today. Position 9 is May 12th pending placement. 10 and 11 is relatively new, so it's going to be reset to June 2nd for status. Position 12, null trust. Position 13 is a waiver of arraignment will be filed by today, and the case is further noticed for trial. Position 14 is reset to May 12th. Position 15 is reset to May 12th. Position 16 is waived to June 2nd, pending placement to a hospital. And position 17 is reset to May 19th, pending status on evaluation. All right, that concludes our competency calendar. We'll move on to Ms. Cameron Williams and Mr. Finley. We are going to address the plea, yes?
And Your Honor, if you can remind me what position this is.
Oh, this is on the DB bench warrant reset, position number 2.
Okay, that's with Ms. Webb. Got it. Thank you.
Yes, thank you. Yeah, all counsel who do not have any connection to this case, you are free to go or free to stay. All right, so Ms. Cameron Williams, just to remind you, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and Mr. Findling will be representing you. Is this a negotiated plea?
This is going to be only non-negotiated, I get, just because of the contact, Judge.
All right. So with regards to this non-negotiated plea, Ms. Williams, I'm going to first hear from the prosecutor, and then I will hear from your attorney, after which I will let you know which recommendation I'm going to accept, and then you can decide if you want to proceed with the plea. Understood?
Yes, ma'am.
Thank you. Ms. Webb?
Yes, Your Honor. In this particular case, the state is recommending 12 months to serve 10 days, credit for time served 5 days, with the balance probated, family violence intervention program enrollment, a stay away from the 13305 Oakview Lane, Alpharetta address, no further contact with John Witcher and Jasmine Grantling. That's John, common spelling, Witcher, W-I-T-C-H-E-R, and Jasmine, common spelling, Grantling, Grantling, and no alcohol, drugs, or weapons as a condition. Your Honor, in that breakout session, the defense did alert me that Ms. Grantling is the defendant's sister. So the defendant would like to have contact with her sister. The state is not opposed to no violent contact with that sister, Your Honor, considering the facts and circumstances, but we want Ms. Williams to be clear that should she violate that condition, she will be rearrested and back here again.
All right. And no further contact with John Witcher and no further violent contact with Jasmine Grantling. Is that correct?
Yes, Your Honor.
All right. Thank you. And Mr. Findling, what's the issue in dispute? I'm sorry, you're on mute, sir.
I apologize. We were disputing the no further contact with Mr. Witcher just because that is the boyfriend of her sister, Jasmine. She isn't, she isn't going to have a lot of contact with him, but they do have a very close-knit family, Thanksgiving, family gatherings, and so on. She wants to be able to go to those functions and be around him. She assured me they don't have a close-knit relationship. She's not really need to have contact with him, but just it would make it difficult to be around her sister without him.
All right, Ms. Harrison, do we have any priors on Cameron Williams? She was position 2 on the DV bench reset.
Last arrest I'm showing is January of this year, and that was the failure to appear. Prior to that was October of 2021.
Okay, thank you. I will accept the defense recommendation of no further violent contact with John Witcher and no further violent contact with Jasmine Grantley, but she cannot return to the 13305 Oak View Lane in Alpharetta, Georgia. I'm assuming that's where Mr. Witcher resides as well?
No, that's my grandmother's home.
And Your Honor, just for the record, at the time of this incident, they did have that address cited as both the sister and the defendant.
Oh.
Did I cut off? I'm sorry.
Yeah.
For the record, Your Honor, the warrants did cite that 13305 address as both the defendant's and her sister's address.
Oh, so it isn't the address of John Witcher?
No.
All right. Well, it's going to be no further violent contact. And in that case, is the stay away pertinent at this time then?
I just wanted the defendant to clarify whether or not she actually resides with her grandmother at that address.
No, ma'am, I do not.
Okay.
I've got a Plantation Trace location.
Yes, that's correct, Judge. That Plantation Trace in Duluth, that's her address, Judge.
All right. So, Ms. Webb, are you still going to pursue the stay away?
Yes, Your Honor, we're going to still ask for a stay away.
What if Thanksgiving is at the grandma's place?
I mean,
well, I hate to be mundane, but it's...
Yes. Well, since there's no violent contact anyway, so that's fine. We can waive the stay away condition, Your Honor, since it is no violent contact.
I just want to inject a bit of reality over here.
Yeah.
So no further violent contact. Okay. All right. So Ms. Cameron Williams, like I said, I'm accepting the defense recommendation. You can return to grandma's place, but you cannot have any physical or verbal altercations with John Victor and with Jasmine Grantley. If there are any altercations with either one and the police get involved, the prosecution has a right to seek a revocation of the probation and have you serve out the rest of the sentence in prison. Is this something that you'd like to go forward?
Yes, ma'am.
All right. So, Mr. Findling, do you stipulate to the factual basis, venue, and ID?
I do, Judge.
All right. So, Ms. Williams, first of all, may I place you under oath?
Yes, ma'am.
The other right hand.
Oh, sorry.
Do you solemnly swear and affirm the information you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Williams, have you recently consumed any medication or alcoholic beverages?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with the representation you received from Mr. Zach Finley?
Yes.
All right. And with regards to this particular case, is anyone forcing you to take a plea today?
No, ma'am.
If you decide to move forward with this plea, you'll be pleading guilty to the charges of battery, domestic violence, and battery, and you would have to give up and waive your constitutional rights to go back to court in the future, have a trial before a judge or a jury, to have the assistance of counsel to be able to challenge the state's evidence, present your own defenses, confront your accuser, examine and cross-examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, domestic violence, and one count of battery?
Guilty.
Your sentence is going to be concurrent with respect to both charges. It's 12 months to serve 10 days, credit for time served 5 days. You'll be placed on probation. Is the plantation trace and phone number a good contact information? And is that phone number a mobile that can receive text messages?
Yes, ma'am.
All right, so probation will contact you as to when and where to report. Do you understand?
Yes,
if you
ma'am.
don't hear from them in 2 days, then you need to go and report to probation at 132 Mitchell Street in Atlanta, Georgia.
I'm sorry, could you give me that one more time?
If you don't hear from probation in 2 weeks, you need to report to probation at 132 Mitchell Street in Atlanta, Georgia. Make sure you have your case number with you, which is 21 CR 005536H.
3568.
No. 21, C as in cat, R as in Robert, 0055368 as in Harry.
Okay.
While you're on probation, you will complete a 6-month domestic violence intervention program at your expense. And you are to have no further violent contact with John Witcher, and no further violent contact with Jasmine Grantley. You're not to consume any illegal drugs, no alcoholic beverages, and no, you cannot possess any weapons or any firearms. I will waive your probation fees from right up to November of 2022. And if you have completed all the conditions, your probation will be non-reporting.
Okay, thank you.
All right. So the sooner you get the classes done, the better it'll be for you.
Yes, ma'am.
All right. Do you have any questions, Ms. Williams, about your sentence?
No, ma'am. So I just wait on my probation officer to call me, or?
Yeah, the probation will call you on your phone or on a text message. Otherwise, like I said, if you don't hear from them, report to them in 2 weeks' time.
Okay, thank you.
All right. Just as a footnote, you are now convicted of battery domestic violence. If there's any subsequent arrest for battery domestic violence, that subsequent arrest will be a felony charge.
Okay, yes, ma'am.
So just stay out of trouble.
Yes, ma'am.
Thank you. That concludes this case.
Thank you, Judge.
Mr. Finley, make sure the paperwork is sent to Katrina.
I will.
I think we are concluded. Thank you very much, Ms. Harrison, Ms. Webb. Ms. Greenhouse, thank you so much for being here.
Thank you.
I'm sorry.
Thank you.
Please,
Thank you
you may
all.
leave.
Thank you.
Thank you, Judge Law.
Yeah,
All
thanks,
right,
everyone.
everyone. Have a good weekend. Take care. Bye-bye.
Bye-bye.